In saying that, I'd like to welcome our witnesses for the first hour today. From the Office of the Conflict of Interest and Ethics Commissioner, we've got Mr. Conrad von Fichtenstein, who is the Commissioner. Sir, it's good to see you. It's been a long time, but we're finally again in front of each other. Lynn Robinson-Dalpe, Director, Advisory and Compliance. And Melanie Rushworth is here again. She's the Director of Communications, Outreach and Planning. Commissioner, welcome to committee. You have 5 minutes for opening remarks. Please go ahead.
Bonjour, Monsieur le Président. Comme vous savez.
Good morning, Chair. As you mentioned, I have with me Lynn Robinson-Dalpe and Melanie Rushworth. I'm pleased to review the role and mandate of our office. We administer the Conflict of Interest Code for members of the House of Commons and the Conflict of Interest Act for appointed federal officials. Given the committee's mandate, my remarks will focus on the Act.
The Act are called public office holders. They fall in two categories. Those appointed to full-time positions are called reporting public office holders. They must follow the Act's general conflict of interest rules, plus its reporting and public disclosure provisions. This means they must give the Commissioner's Office detailed personal and financial information about themselves and, in some cases, their family. The Office keeps most of that information secret. However, we are required by the Act to disclose some specific information. We do that in a reductive form, and it will be posted on the registry, which forms part of our website. Those appointed to part-time positions are referred to simply as public office holders. They have to follow the Act's general rules, but they do not have reporting requirement. La confidentialité et la transparence sont.
Confidentiality and transparency are both key to our work. Confidentiality encourages public officials to communicate freely and openly with us and to ask us for advice when faced with a situation that may put them in a conflict of interest. Transparency means that we are as open as possible with Parliament and Canadians. This helps ensure the credibility of the Act and its administration.
Our work really supports three objectives. First of all, we foster public confidence that the actions of elected and appointed federal officials are free from conflict of interest. Secondly, we enable the most competent and qualified people to move in and out of the public service without any problems by helping them manage their conflict of interest. And lastly, we examine and report on allegations of conflict of interest that involve elected and federal appointed officials.
Our tools include one-on-one interface with public officials, live educational sessions, online training, and investigations. A lot of the office's work is outlined in our latest annual reports that were tabled in Parliament in June. The report, under the Act, identifies 6 legislative changes that could help it function more effectively and administer the Act more efficiently.
I suggest you allow the lobbying commissioner to step in front temporarily if there is no conflict of interest to the commissioner. I.e., if I get run over by a truck tomorrow, there's somebody to do my job, which would be the lobbying commissioner. Secondly, we add the notion of apparent conflict of interest to the general duties of public office holders in a way to avoid the appearance of conflict of interest. Third, to allow some assets to designate it as exempt assets if they pose no risk to conflict of interest. For instance, electronic trading funds pose no conflict, but they are prohibited under the Act right now. Fourth, to allow public office holders to participate in matters affecting the private interests of their friends and relatives if those interests are the same as those of members of a broad class of which they are part of. This would make the Act consistent with the Code. Fifth, to allow the Commissioner to approve outside activities that don't conflict with public office official duties but are presently forbidden. For instance, teaching at university on a subject which they know something about. And sixth, raise the maximum administrative monetary penalties to stress the importance of the reporting requirements of the Act. Right now, they're extremely low, and they look like traffic offenses. That's basically my presentation. I will be happy to answer any of your questions.
Okay, thank you, Commissioner. As I said at the onset, it's been a while, and so lots to get caught up on. We're going to start our round of questioning with 6 minutes. I'm going to go to Mr. Barrett. You have the floor, sir. Go ahead.
Merci. Bon matin, commissaire.
Good morning, Mr. Commissioner.
Have you back at committee. It's been a year. A lot's gone on since then. I'll get right to it. Canadians can see which companies a designated public office holder held shares or options in before entering office, but not the value of those holdings. Does that level of disclosure give the public enough information to assess a potential conflict, or would value ranges better serve the public interest?
Well, the crafters of the Act already decided it's important for the public to know what a person owns, and it leaves it up to the Commissioner to make a decision as whether what to do with them. Most of the things that they own which are of consequence are either disposed or placed in a blind trust. It's only items that are below a minimum threshold that people can hold. And it seems to me that was a decision the legislature took to say, you want to respect the privacy of people, you want to encourage people to come. They don't have to disclose everything they own and how much. They have to deal with it in such a way that there's no conflict of interest. And that's the choice the legislatures took.
Would you suggest that a parliamentary, that a review of the Act by Parliament should consider that question? You having said that this was a decision taken by Parliament at its last review to leave it alone and at its inception, there's no value ranges, and so they go into the blind trust. But if it's a high performing stock, well, the trustee's not going to liquidate that. They're going to leave it in there, and the public office holder knows what they put in.
Yeah, but it's as you know, first of all, it's in a blind trust. The public officer has absolutely no idea what the trustee will do with it, and he cannot give him direction. So the trustees, most of them, will just hold it. They can trade, that's a privilege, obviously, and they will do, but they also have to account later on to the person who placed the things in trust. So the best course is to basically just a passive holder, and that's what most of trustees do. But they are not restricted to it. Then secondly, if the public office holders obviously knows what he placed in the trust, etc., and if he makes decisions that could be germane to what's in the trust, etc., in those cases, we establish what's called a screen, and in effect, we make sure that the decision maker does not make decisions regarding his very valuable asset that he has in the portfolio, which will be directly affected by his decision, and it is an asset that is specific. It's not part of general legislation or covered by legislation or covered by a class.
So would mandatory divestment and independent reinvestment remove the perception and simplify compliance? The issue, if I may, the issue with the blind trust is that you take, for example, a prime minister who would have the clerk of the Privy Council, which is a political appointment, and their chief of staff, a political appointment, are the overseers of it, and there's no public indication when that screen has been used. And so there wouldn't be a need for a screen if the funds were simply divested and then reinvested by an expert, financial manager.
You're right, but it's a pretty simplistic solution, because you imagine you're suggesting that somebody who enters into public service sell all his assets, increase a great tax liability, obviously, for that year, etc., and only then leave it up to a trustee to deal what's best, what he thinks, the trustee thinks is best with the assets. It's something that can be done. I certainly wouldn't recommend it because I think it would be very much discourage people from entering into public services. It would suggest that, you know,
If I may, Commissioner.
great tax liability and B, also very much interference in his personal.
If I may, sir, the objective here isn't about the encouragement of folks to run for office or to avoid tax liability, so much as it is to ensure that Canadians have confidence that the decisions taken by these public office holders are those that are in the best interest of their public, and there can be no appearance of a conflict or no perception that that they're taking decisions that are going to enrich themselves, and that's the root of my previous question. These conflict screens can cover dozens or hundreds of companies, but does your office have any ability to independently verify that the screen is triggered when required, or is it simply up to the political appointees of the designated public office holder to inform you?
Let me first of all
quick response,
correct
sir.
you with your assumption. The Act has specifically sets out 5 purposes. The last 2 are encourage experienced and competent persons to seek and accept public office, facilitate the interchange between private and public sector, minimize the conflicts between private interests and public duties, and provide resolution of those conflicts. So part of my job is exactly that, making sure that the best people can get into the public service and out with the least conflict of interest.
Thank you, sir.
Good day, Mr. Commissioner. And what I find concerning is that for the Prime Minister of Canada, we're in a never-before-seen situation. Brookfield, which is a management company, manages about $1 billion. The Prime Minister was responsible for this last January. According to the data bank by Statistics Canada, Brookfield controlled 916 companies as of December 31st, 2024. In your registry, and this is where I have a question, we can see that Mark Carney divested and on shares and other rights by creating a blind trust. And in your report, in your registry, it states that you implemented a filter against conflict of interest, and this is significant. This is appropriate compliance. I would like for you to explain how this conflict of interest filter works regarding a particular situation. This is very different from Paul Martin with his boat company. Answer: this filter is permitted with Section 29. The Commissioner can decide the measures to be applied so that public office holders are compliant to measures in the legislation. We can come to an agreement with public office holders. So this is what we use, and it went to the Court of Appeal, the Federal Court of Appeal, and we were told that the filter is an appropriate measure that can be used. Now, for the case of Mr. Carney, he divested and stated that everything was put into a blind trust. I can't remember the word in French. we want to avoid that there's a situation where a decision is made and one of his companies will know what to do in order to increase its value. And so that's why we created this filter. And every element presented to the Prime Minister needs to be assessed to see if there would be any issues. It'll have to be done by company. And then there might be cases where he would need to recuse himself. But if it's a general matter, it won't be necessary. But let's say that the Prime Minister needs to recuse himself 100 times because there could be a conflict of interest or appearance of conflict of interest. Is he seated in the right spot? I'm not asking you to respond, but that is a question that I've asked myself. Now, regarding minimal taxes at the global level, at the OECD, we want to avoid tax evasion by having a minimal percentage of 15% for multinational companies. These multinationals use tax havens in order to avoid paying taxes, and the country that hosts that would receive at least 15%. In C69, we adopted in June 2024 a legislation on minimal taxes that would start being implemented in 2025. The fiscal year started last year, and in November 2024, 2 months before the implementation of the law, Brookfield Asset Management moved its headquarters to the United States, and so it no longer needs to pay that 15% minimal tax. And at the G7, before going through the House of Commons, the Prime Minister decides during the G7 to exempt the United States because he transferred the headquarters to the United States and exempted the United States of that minimal global tax. Do you not believe that that's an ethical issue and could cause the appearance of a conflict of interest? And do you think that your filter could apply? Answer: this is a tax measure. It's universal. It applies to all companies, even Brookfield. That's something that needs to be done. There needs to be universal laws that will impact companies like Brookfield. Apologies, but at the G7, the United States were excluded, and so they were not required to pay their 15%. When did that decision happen? At the G7. It's the Prime Minister himself who made that announcement. And it would have been good for us to be able to ask the question in the House. This applies to Brookfield and a lot of other companies as well. And the reason behind that was because of frictions with the United States and President Trump. It was not in order to favor a single company here. Brookfield perhaps benefited from this, but I'm sure other companies did as well. If this is a legislation that applies generally, we wouldn't need to use the filter. Thank you.
Chair, Commissioner, I want to ask you some questions about the Prime Minister's so-called ethics screen. First of all, the ethics screen is being administered by the Prime Minister's Chief of Staff and the Clerk of the Privy Council, correct? Yes. So we have the Chief of Staff, who is appointed by and works directly for the Prime Minister, and the Clerk of the Privy Council, who serves at the pleasure of the Prime Minister. These two individuals are hardly independent of the Prime Minister. So in the face of that, what assurance do Canadians have that the screen is being implemented and enforced properly?
Well, let's be practical. Anything that goes to the Prime Minister for decision goes to either one of these men or both. They are in effect, the key holders for what gets on his desk and what he deals with. So they are the logical ones to make sure he does not get involved in these things. And
Well, sir,
I'm just talking about purely administratively. If you want to install, you're the key people who determine who the last person, what goes to the Prime Minister are these two people. They, of course, have a whole...
Well, sir, I understand that it's administered by the Chief of Staff and the Clerk of the Privy Council, both of whom serve at the pleasure of the Prime Minister. And so I'm asking you in the face of that, what assurance do Canadians have that the screen is actually being enforced properly? Are there any independent mechanisms that your office has to ensure that it, in fact, is being applied properly?
Because their interest is the same as the Prime Minister. They don't want to run a house, see the Prime Minister whom they serve run afoul of conflict of interest. That causes both political and legal problems. They are there to make sure that he complies with the law. It is their duty. And they have been assigned that duty, and surely they're going to exercise in such a way that there does not appear or does not arise a conflict of interest. That's their job.
So your answer is that the effectiveness of the screen rests on the Prime Minister's Chief of Staff and the Clerk of the Privy Council, right?
I rely on the integrity of the senior people in government acting in accordance with the law, because it's in their interest, in the interest of the Prime Minister.
Sir, is there are no independent mechanisms in place, correct?
No, not at all.
Okay.
I have just, don't forget, it's not there. Each one of them has a whole body of people working under him. They've all been instructed. We have given them lessons on how to do, etc. When in doubt, they will consult with us. They are very keen to have that nobody can raise a conflict of interest.
Well,
and that's their job.
Well, all I can say, no reporting, no transparency measures, no checks and balances. We're just left to take the word of Mark Carney and his two top advisors. I would say that falls short. Now,
Mr. Commissioner, could you describe the reporting requirements required of public office holders under the Act?
Okay, why don't you walk them through, Lynn?
So essentially, when a public office holder, a reporting public office holder is appointed, they are provided a confidential report that they need to disclose. So in there, they have to disclose information on their assets, liabilities, outside activities, corporations, any information that in addition to that, any information that the commissioner may be used to provide some guidance. So family members that have interests or that have dealings with the federal government, friends that have dealings with the federal government. So all of that is provided in the confidential report. At that point in time, the office, an advisor in the office will review the disclosure and establish which requirements are required. In the case of assets or assets that are deemed controlled, divestment is required. In some cases, a reporting public office holder must also step down from private companies in which they are like director or president or chair. So all of these measures are reviewed with the reporting public office holder, and they have a period of time to comply with that. So essentially, there's a lot of information, very similar to what is disclosed by members of parliament, but there are more concrete measures that are required for them to comply with the Act.
Great.
Let's go back to what we were talking about earlier. I understand what you need to apply, but I want to look at the core of ethics, what should be. And I'm waiting on your office to give us suggestions regarding what should be. I want people to come into politics But if structurally what they own causes a structural conflict of interest, for example, you have a company with 916 smaller companies with an investment of $1 billion and a prime minister who proposes C5, for example, railway, natural gas, pipelines. These are all things targeted by C5, Westinghouse, nuclear facilities, ports. These are all things that are targeted by C5. And I think that there is an appearance of conflict of interest. And in this case, this legislation was passed without discussion, and we weren't able to measure this. Do you not believe that not knowing how much this is going to have an impact on his blind trust, he probably knows that Brookfield will benefit from it? And I think that this shows a structural deficiency that is unacceptable. We can't make decisions when we know that they will serve us. Should everyone come do politics? I think people need to make a choice. And when we're looking at such a situation, I would expect from the Commissioner of Ethics to give us the tools to avoid conflicts of interest. The example that you gave is a selection of projects. This was in the national interest with these projects. This doesn't show who will be doing the work, who will be receiving government support, who will be choosing companies, what the impact will be for companies. So we need to look at Brookfield, yes, but we are not at the moment of making a decision regarding who is going to benefit from all of this. We need to see what C5 will do, who will be chosen, which companies. At that time, those who are responsible for these screens will decide, is one of these companies going to participate? Is it Brookfield? These are all things that will be subject to the screen at that point. Currently, there is not a conflict of interest, and the screen does not apply. I would like to come back to that screen for conflict of interest. You implemented this because of the situation. And so, this has to do with the conflict of interest, somebody coming from the private sector that is not becoming a simple minister. That would be a different case. This is the prime minister that makes all of the decisions for the country. Your screen is administered, and it's not you that implements it. You're not the one who is in constant contact with those two people in cabinet. But do you not believe that somebody external should have to do this? And before giving someone the opportunity to use this screen, did you verify whether or not those people have a conflict of interest? Microphone, please. I'm speaking of at the office. I believe that that conflict of interest screen was managed by you and not by people who are close to the Prime Minister, who are hired by the Prime Minister, have you verified their potential conflict of interest? Was that verified before making them responsible for the application of the conflict of interest screen? That would be a conflict of interest for me. I cannot participate and judge at the same time. If there's a conflict of interest, I would have to be the one to decide. Now, how does this screen work? I am not satisfied with this screen. I don't understand how it could reassure Canadians. It's a statement, but the implementation is insufficient. It's not my opinion. It's that I'm not receiving an answer to my question, Mr. Commissioner. Thank you, Mr. Thériault.
I do have a couple of questions, and it relates to the specifics of the reporting mechanism, Commissioner. When a public office holder, does a public office holder have to declare either deferred stock options, stock units, or any future bonuses tied to any of the previous companies that they were affiliated with? Would that be part of their ethics disclosure?
Yes, it is.
Okay. So here's the question that I have, Commissioner, and it's along the lines of what Mr. Thériault was asking. When the screens are set up, wouldn't that cause a reasonable person to conclude that the public office holder is in fact benefiting from those deferred stock options, units, and future bonuses, despite the fact that the blind trust is being set up? Now, if that public officer holder, for example, was a prime minister whose major policy platforms were, for example, housing, infrastructure, EV mandates, and all that stuff, wouldn't that cause a reasonable person to conclude that they are in fact benefiting, blind trusts notwithstanding, screens notwithstanding, that they are in fact benefiting as a result of the decisions that are being made, major policy decisions in this country? Wouldn't that cause a reasonable thinking person to conclude that there is in fact a conflict and that person is in fact benefiting as a result of these decisions?
Well, you have just enunciated the major argument why people don't like the idea of apparent conflict of interest, because it is possible to view things that way or other way. You can also put it the other way around, saying he has earned those deferred benefits already. He's getting them in the future. He's getting them from one of the largest companies in the country. So how can you personally be, where is the conflict of interest? There is no way that the decision will have an impact on the deferred money that he's getting in the future. Now, that's why when you talk to a parent, conflict of interest, you have to take the balance of how people see it, and is it possible to give the apparent conflict of interest, or is it really just unfortunately, it looks like that, but effectively there is nothing that influences the personal interest of the person that's involved. They are very appearances of conflict of interest, as I meant in the decision that was read out and that Mr. Oliphant suggests, is you take basically how does a reasonable person outside, knowing fully well the situation, would regard that, etc. And this fully well the information is key. You have to understand how a deferred benefit works, how it was earned, and etc. So I don't know how to answer your question, Mr. Chair. It's the best I can do.
Thank you, Commissioner. I really appreciate the time that you've spent with us today.